rate at which allegations are made before the Madlanga Commission probing allegations of criminality, political interference and corruption in the criminal justice system can be difficult to keep up with. That is at the rate at which they have sent shockwaves through the nation. But fear not, as we will keep you updated, one allegation at a time. I'm Kani Mapanga and this is the weekly Madlanga Wrap.
It is my view that the attempt to disband the political killings task team was due to the influence of particular organized crime cartel over the Ministry of Police. It means crime intelligence remains the cornerstone of SABC operations. The operations within the cartel, all syndicates within the cartel, highly organized in terms of networking. Cartel activities are originating from both in the other world as well as broad society at local level.
As the Commission continues to probe the alleged extent to which criminal cartels have infiltrated the criminal justice system, 3 partially in-camera witnesses presented their evidence on the alleged experiences and alleged interference that accompanied their investigations into criminal cartels. The main lens upon which they delved into this theme was through the murder of QTech employee Armand Swart, who died in a hail of 23 bullets in a case of mistaken identity. This after the company he worked for, QTech, blew the whistle on tender manipulation at Transnet, which implicated alleged cartel member Katiso Katie Molefe. Witness A and B's testimony on this high-level probe, which has changed their lives, raised critical questions surrounding South Africa's bail regime and further escalated the allegations about the Judiciary, which paints this institution as one that is allegedly acting in collusion with these criminal cartels. Witness A and B are the detectives under organized crime that later went under the intelligence wing. They're both assigned to the murder case of Swart. However, after a thorough investigation that allegedly linked Katiso Molefe as the mastermind behind the murder through CCTV footage at the Vereniging premises, vehicles which contained a world of exhibits and electronic communications between the alleged hitman, former cop Michael Buletau and Molefe. The murder accused Molefe, who is alleged to have a shoddy past of the use of a false identity and a previous drug-related conviction in the UK, was able to secure bail. Witness B listed some of her concerns earlier this week. Let's take a listen.
I was very uncomfortable with what was transpiring. In particular, it felt to me that the judge had already predetermined the matter. Although this is not uncommon, it seemed he was also intent on giving Mr. Molefe, who was accused of very serious offences, lenient bail conditions. In particular, 2 exchanges are relevant. Before I deal with subparagraph witness B, can you confirm this paragraph?
Yes, I confirm, Commissioners.
With this correction, perhaps witness B, it's acting judge president, not acting deputy.
Noted, Commissioner, will be rectifying that.
At paragraph 116.1, in one of the exchanges related to the conditions related to Mr. Molefe's movement, Mr. Molefe's lawyer asked for movement within the Gauteng province or even house arrest. The judge of his own accord inquired whether that would not be too restrictive, as Mr. Molefe had businesses in other provinces. Mr. Molefe's lawyer responded that she does a number of these matters where there are business-related reasons for travel. These would be communicated and written permission of the investigating officer would be sought, which cannot unreasonably be withheld. The judge then raised the issue of the child and girlfriend who live in KZN, to which Mr. Molefe's lawyer responded that they can travel. Despite Mr. Molefe's lawyer's acceptance of this well-established condition, the judge made a comment that bail should not be a punishment In the end, the bail condition granted was basically that Mr. Molefe can leave after informing the IO, and the IO should not object unless there is a valid reason. Witness B, can you confirm this paragraph?
Yes, Commissioners, I can confirm this one. And maybe to have some comments on this one.
Yes, Witness B, you can continue.
My main concerns in what the judge expressed there is to say if this would not be too restrictive. I felt like he was already showing the signs of lenient towards the accused, because the accused was the one applying, and he already placed on record what he's willing to take. But the judge is the one who feels it's too restrictive. I felt like the judge is having too much lenient towards the accused, and that's where I already knew that he was going to be granted bail already.
To unpack Witness B's concerns that speak to South Africa's bail regime, we have roped in legal analyst Ulrich Roux, the director of Ulrich Roux and Associates. Ulrich, thank you so much for joining us this afternoon. Quite important testimony coming out of Witness A and B that really speak to the consistent concerns about South Africa's bail regime, which garners a lot of criticism for favoring the alleged criminals over the victims. Is this case another illustration of this concern?
Hi, good afternoon. Thank you for having me. I think what we must remember is that Mr. Molefe was initially refused bail, and he was then granted bail when he took that decision on appeal to the South Gauteng High Court in Johannesburg. What we must always remember is that bail can never be seen to be a form of punishment pending the finalization of a trial. It's the old cliche rings true of a person is innocent until proven guilty. If there's no proper reasons that have been forwarded by the state, then a person should essentially be granted bail pending the finalization of that trial. Now, our Criminal Procedure Act has different schedules in accordance with which bail applications are run by courts. If a person is faced with a Schedule 5 offence, then he must show that it is in the interest of justice for him to be released on bail. Whereas if he's charged with a Schedule 6 offence, he must show exceptional circumstances which permit his release on bail. Now, the factors that are taken into account by a court are, is this person a flight risk? So in other words, if he's released on bail, is there a high likelihood that he might escape his trial? In other words, flee the country and live the life of a fugitive in order to avoid being prosecuted and possibly convicted? Secondly, is there a high propensity or chance that he might commit another offence whilst out on bail, which is an important consideration taken into account by the court? And then thirdly, would he interfere with the South African justice system, the bail system, or possibly tamper with witnesses? Now, the court needs to look at all of these factors, and if the court is satisfied that this is not the case, then that person should be released on bail. Again, bail should not be seen as a form of punishment pending the finalization of a trial which determines a person's guilt or not. Now, obviously, the courts are not going to please everyone with the decisions that are made, and I've heard the testimony now of Witness B, but I think what she forgot to mention is that the judge would have read all of the papers before the court prior to considering the application, and as judges do, would have formed a possible opinion on the papers before it, and that could accordingly have given the investigating officer the idea that the judge had already decided that Mr. Molefe should be released on bail. But that is commonplace in appeal matters. The judges need to prepare for the appeal, and they need to read the papers prior to making a decision. If the investigating officer or if the state is not satisfied with the decision for Mr. Molefe to be released on bail, then they are welcome to appeal that decision and approach the Supreme Court of Appeal if they feel that he is indeed either a flight risk or that he would interfere with possible state witnesses and with the South African justice or bail system. But again, in handing down judgment, the court found that there was not sufficient evidence which showed that he would, either evade his trial or that he would interfere with witnesses.
Yes, just to come in there, we understand that this was a Schedule 6 murder case, so it is possible that an accused with a questionable record can be granted bail because the grounds upon which the court looks at isn't centered much on the merits, but whether or not you can secure this accused's presence in the court to finish their trial before the criminal justice system.
Well, our case law is clear that the onus rests on the accused person to show exceptional circumstances which permit his release on bail. Now, in practice, what we normally do is we take on the merits of the state's case. So an exceptional circumstance could be that, the evidence placed before the court during the bail application has been refuted by the accused person, or that it is not a strong case against the accused, and that amounts to an exceptional circumstance. Once again, if the state cannot successfully prove that a person like Katie Molefe will evade his trial or will interfere with state witnesses or will commit another crime whilst out on bail, then that person should not be kept in custody pending the finalization of the trial. Our bail system, and we hear it more often in our courts when we are involved with these proceedings, is that the South African prison system is under severe pressure. There are too many inmates in our prisons. It's overcapacity. You have up to 40 people sleeping in cells which should be accommodating 6 people, for instance. And that plays a large part in people being granted bail, and that the court shouldn't just willy-nilly refuse a person's bail application and put additional pressure on this system, that the prison system in South Africa. Having said that, of course, if the state can prove that a person or an accused person would, there's high likelihood that he would, through his previous actions, commit a crime whilst released on bail, then that person should be refused bail.
And lastly, Ulrich, does the bail regime need an overhaul? And if so, how does one achieve this while respecting the principle of an accused being presumed innocent before proven guilty? How do you strike that balance?
Yes, that is obviously a very difficult question. I think it would be impossible at this stage to have an overhaul of the bail system. But at the end of the day, we need to ensure, and South Africa needs to ensure, that our prosecutors and our investigating officers are properly equipped, are properly, trained, and have sufficient knowledge and experience in order to prosecute these matters and run bail applications effectively. Once again, if there is evidence showing that this person does not qualify for bail, then the NPA and the South African Police Services need to ensure that this is the case. At the end of the day, a judge or a magistrate is an objective person and is an objective person who makes an objective decision based on the evidence presented to him or her in a court of law. And the state should thus ensure that the evidence presented, should they oppose the release of a person on bail pending their trial, must be of a high quality in order for a judge to make the right decision in their minds. Unfortunately, it sounded like this witness B alluded to the judge having been possibly bribed or coerced, or that there was underhanded tactics displayed in reaching this decision of releasing Mr. Molefe on bail. But unfortunately, without any proof substantiating that is all that remains. It's purely an allegation and speculation.
All right.
And at the end of the day, objective decisions need to be made.
All right, thank you very much. That was our legal analyst, Uruk Roux of Uruk Roux and Associates, sharing his insights on the bail regime in South Africa. Of course, as he correctly states, this formed the foundation upon which the allegations against the judiciary escalated. But we'll chew on that evidence a bit more after the break. And we're back. At the center of Witness A and B's concerns over the initial bail application of Katiso Molefe is the judiciary. This as Witness A and B's concerns implicate top judge, acting judge President Aubrey Ledwaba of the country's busiest division, that is the Gauteng High Court. The two detectives have alleged that it was known that Molefe would be released on bail as he was going to allegedly pay his way out. This, paired with the alleged conduct of the top judge as he presided over the matter, raised the eyebrows of Witness A and B. Let's take a listen.
When the judge said it will be a burden on Mr. Molefe, I felt all the pain that came with the burden, given the fact that he was proposing that he wouldn't mind to do it, but the judge is the one who feel it will be a burden. It was an agony for me to sit in that court now listening to all this, because I already knew the verdict while sitting there. So to sit there further, it was really, really a pain to me. I even went out, made a phone call to my commanders to say, can I please withdraw? I can't sit here any longer because it was a pain. But they said, feel all the pain that you'd feel. We need a feedback.
Thank you, Witness B. Commissioners, the exchange Witness B is referring to can be found at CJC 4.5, and that is at page 323, line 20, until page 324 at line 8. Paragraph 116.3, the judge took the view that Mr. Molefe had been candid about his past conviction when he had in fact not. As set out above, he only addressed his previous drug-related conviction and the fact that he was traveling with fake papers when he saw the state's opposing papers in his bail application in the magistrate court. The judge accepted the version that Mr. Molefe made the disclosure to his previous representative. Moreover, from the interaction, it was clear to me that the judge did not have an interest in the conviction because it was 20 years old and it thus carried little weight. Witness B, can you confirm this paragraph and provide commentary, if any?
I happy with the way it has been read on record. I have no further comment.
Commissioners, and reference to this interaction is at CJC 4.5, page 331, line 11, until 332, line 11. Paragraph 117. Nevertheless, Mr. Molefe was granted bail of 100,000 rand with conditions that are questionable. In particular, he was ordered that 2.1, he should report to the nearest police station twice per week on a Monday and a Thursday. 2.2, he should be in the province of Gauteng and can only leave Gauteng province after informing the investigating officer in writing where he would be going, and the investigating officer would not object unless there is a valid reason for him or her to object. 3.2, the applicant should interfere or communicate with the state witness mentioned in the indictment.
These allegations prompted a statement from the Chief Justice of the Republic of South Africa, Mandisa Maya, where the judiciary's top judge called on any person who has evidence of a judge's misconduct to promptly lodge a complaint against that judge with the Judicial Conduct Committee of the Judicial Service Commission. This has not happened yet. Maya added that Judge Ledwaba strenuously denies the bribery allegations, adding that he will not take special leave and that he is seeking legal advice with the wish to be afforded an opportunity to give his side of the story at the Madlanga Commission. To unpack this, we are joined by Judges Matter Coordinator Alison Tilley to really deal with this complex issue where we're now in the dangerous terrain, Alison, where you have a judge that is now being implicated in this evidence just based off how their conduct was perceived. It hasn't yet been proved that there was anything untoward with the way this bail assessment was made in the case of Katiso Molefe, but it seems that from witness A and B's vantage point that they have questioned the conduct of the presiding officer when he granted Katiso Molefe bail. So although the allegations are untested, they are still quite serious and they could harm the integrity of the judiciary as they stand currently right now. You are dealing with an acting judge president of the busiest division in this country, that is the Gauteng High Court. Should he have taken special leave in this instance until this matter is resolved?
Well, I think certainly given that he had a discussion with the Chief Justice and it does seem that she would have preferred him to take special leave, I think there is an argument that he should have done so. The difficulty here is simply that at this point there is no allegation in front of the JSC. There's no complaint. What there is a statement and a commission of inquiry. Obviously, that's a serious thing. It's a statement that was made under oath. It's certainly more than just a rumor or gossip, and so we do have to take it seriously. But what I'm certainly worried about is the fact that there is no complaint in front of the JSC at this point.
Indeed, Alison, and that is the question that I wanted to ask next about how futile an exercise it could be to actually go and clear your name before the Madlanga Commission when legislation provides for judges to be disciplined through a very specific process, and it is designed that way to serve a particular reason. Would it not be better for this matter to be handled by the JSC, as we know that even if the Madlanga Commission could make a recommendation on this, it could only be to refer the matter to the JSC, as they do not have the powers to discipline a judge?
Exactly. I think that it should go to the JSC. The difficulty, of course, for the JSC is that there's no evidence at this point. There are people who are sitting in court who were concerned, who wondered why a decision was made, questioning whether the judge should or shouldn't have given bail. That's really not going to be enough for the JSC. These are allegations that are being made by the police, and the police are, of course, empowered to investigate allegations of corruption. They can subpoena documents, they can speak to witnesses, and it does seem to me surprising that at this point all we've heard are concerns, surprise, really was this a good decision? Given the seriousness of the allegations, given the seriousness of accusing a sitting judge of corruption, I think I would have expected more, and certainly by now, as the Madlanga Commission has been underway, and we would have hoped these matters would have been dealt with quickly.
Given the fact that we'll only get to phase 2 around the end of November, well, that is what is expected, where implicated persons will get an opportunity to respond to the allegations made against them. In the midst of this, the Gauteng High Court Division still has to do its work. Acting Judge President Aubrey Ledwaba is not only the acting Judge President, but his former role is the Deputy Judge President of that particular division. So he's quite a senior judge within the Gauteng High Court. What does this mean for the matters that are currently heading towards that particular division. Will he be able to preside over these matters? Will it have any impact on the confidence or public confidence in these cases? We know some of the most high-profile cases that we see in our country head to the Gauteng High Court, and the Deputy Judge President does play a role in the allocation of these matters and sometimes has to sit in these matters. Does this affect public confidence? Will he be able to sit on these matters comfortably knowing that the litigants as well as the public trust the process that they are seeing before the justice system?
I think it might well affect confidence in that court, and I think that's why it's so concerning and why it has to be resolved quickly. It's a very important position, as you say, allocating matters. It's one of the biggest. It is the biggest division. It has the highest number of cases, and the cases are generally very important. So to leave this matter hanging and these allegations, open, undealt with, it's very unfortunate, and which is really why I think from the beginning of the Madlanga Commission, we've said that if there are to be allegations made around judges, that they should be made quickly, and that they should be made with evidence, with appropriate evidence, bank records, anything that would substantiate allegations of bribery.
Indeed. And lastly, it's often misunderstood, this portion, but what is the level of evidence one needs to tie a judge to these kinds of serious allegations that could not only harm the reputation of the judiciary, but also result in them losing it all, essentially? And perhaps emphasize again why the removal of a judge in South Africa's judicial system is such a difficult process in terms of Section 177 of the Constitution.
Well, it's obviously intended to protect the independence of the judiciary and precisely to protect judges from, just unfounded allegations. Litigants are often very unhappy. The police, in this instance, unhappy that somebody they'd arrested was being given bail, and it does tend to be the allegation as well. Maybe the judge is biased. The judge, for some reason, preferred one party over the other. The way that we deal with these allegations is to put them before the JSC in a process where these things can be weighed up, and at this point, that's really, I think, what we're looking for is that complaint backed up by evidence of wrongdoing.
Indeed. Thank you so much for your time. That is Alison Tilley, the coordinator of Judges Matter. That's the official judicial watchdog that keeps a close eye on South Africa's judiciary. Again, Alison Tilley emphasizing that at this point, it's quite concerning that although these allegations have been placed before the Madlanga Commission, there isn't a single complaint that is sitting before the JSC at this stage that can test these very serious allegations that run the risk of harming the integrity of the judiciary, which is one of the guardians of our constitutional democracy. That brings us to the end of our inaugural Madlanga Wrap. The Commission will continue with its hearings tomorrow at 9:30 a.m. with a new witness, as Witness C has to write exams. We'll catch up next week on Sunday at 5 p.m. sharp on what this week's evidence will reveal to the nation.